My lady, my lords, I was going to take you to the case of Hämäläinen, which is a Grand Chamber decision that considered the position in Finnish law, which required those who undergo gender reassignment to change any marriage to a civil partnership. That was the particular context. But what the Grand Chamber did was to identify what was significant in the context of Article 8 from the case of Goodwin, as well as restating what I think my Lady Hill say are general principles. But if we can just look at this case, it is in 109, volume 13, and it's 3783. But the particular paragraphs that I'd ask the court to look at are at 3798, paragraph 65, under the heading General Principles Applicable to Assessing a State's Positive Obligations.
Sorry, paragraph again?
Paragraph 65, my lord, on 3798,
Fine.
page 70, internal pagination. That's the beginning of the paragraph. And then what I particularly emphasise is over in paragraph 66 on page 71, that certain factors have been considered relevant for the assessment of the content of these positive obligations on state. Some of them relate to the applicant. They concern the importance of the interests at stake and whether fundamental values or essential aspects of private life are an issue. And we say that's clearly the case if you have a situation where the person's gender identity is being put in doubt or undermined. And what the court emphasised, if we go on to see there, is the impact on an applicant of discordance between the social reality and the law, the coherence of the administrative and legal practices within the domestic system being regarded as an important factor in the assessment carried out under Article 8. And obviously there's reference to Goodwin, and we say those are two important principles that apply here on the basis of findings of fact of the court below. Other factors relate to the impact of alleged positive obligations at stake, and that includes whether the obligation is narrow, broad and indeterminate. And whilst clearly in Goodwin, the court concluded that the positive obligation has required the fundamental change to the legal system in the United Kingdom. That change having been made, what we submit is in issue here is a narrow obligation on the respondent state to mask information where it is relevant to any public obligation, so that it isn't used in order to undermine the person's current gender identity. We then see at 60...
I've been worrying a bit about that.
Yes.
This morning and the previous conversation. Are you suggesting that I think you're suggesting that only gender identity information which suggests a change of gender should be masked. But wouldn't that lead to the result that everybody else's gender information would be there for all to see, so that if it wasn't there, wouldn't that lead to the same problem that you've got with the special customer arrangements?
That wouldn't lead to a problem, because what would be available would be the current gender details, and that's what would be available.
Not anything previous.
Yes, yes.
That's if you get rid of all changes of name. Oh, sorry, this is just gender.
Gender, yes. Gender. So it's changing gender details, and so that wouldn't have the problem of drawing.
It wouldn't draw attention. Yes.
If we then go on to 67, again, which again I accept is a common observation of the court. But when assessing factors to be taken into account of the breadth of the margin, where a particularly important facet of an individual's existence or identity is at stake, the margin allowed to the state will be restricted. And again, that's a reference to Goodwin, as well as other cases. There is also a question of whether there's a consensus within member states. And we submit that this issue falls within the consensus of member states that formed the basis of the judgment in Goodwin, because it was recognised that individuals are entitled to a congruent gender identity, that administrative and legal practices needed to ensure to be coherent. So we fall within the area in which there is a consensus about respect for current gender identity, having undergone gender reassignment. And so we respectfully submit that we are in the category of case where the margin would be narrower, and therefore the Secretary of State's obligation to demonstrate justification is more exacting.
It doesn't
Striking the balance.
doesn't take one very far, does it? I mean, it says the basic principle, and then it says in paragraph 68, the margin of appreciation, of course, with the possibility to amend the data relating to their civil status. I mean, basically, it leaves it very much for the member states to develop a system which, as far as possible, protects the interests involved here. It doesn't tell you quite where they should draw the line.
Well, what we do know from Goodwin is that it's not acceptable to operate a system where there is discordance between the individual social...
I was just asking whether this case adds anything. I don't think it does.
Well, what it seeks to do is to take what's important from Goodwin in identifying the factors of relevance in the assessment of Article 8.1 and where there's a positive duty. It draws those elements together and emphasises significantly, we say, that it is the coherence of administrative and legal practices that they emphasise as being important, as it was in Goodwin. And so it's not an answer to simply say, well, we've now afforded legal recognition to you through the Gender Recognition Act. We need to be able to demonstrate that in practice and in effect, there does not continue to be administrative and legal practices that lack coherence, because the individual, when they access particular services, is being identified as transgender as opposed to being treated as a woman. And that's why we sought to emphasise this part of the Grand Chamber's judgment as to what they took as being significant from the Goodwin judgment. It's correct that in the particular context, the court concluded that it wasn't disproportionate to require individuals when they did marry to change their marriage to a civil partnership because of the law in Finland, as it used to be in the United Kingdom, that marriage was between it was not same sex. So that was the particular conclusion, that it wasn't disproportionate in that context. But we say it's significant what they identified from the Goodwin judgment as being of significance going forward, accepting, of course, that in Goodwin it was for the state to go away and make the appropriate legislative changes. And they now have to be judged by those standards as to whether they've achieved what the Strasbourg court requested that they should. What is significant, we respectfully submit, about the Court of Appeal's judgment here, and indeed the judgment below, is that nowhere in the analysis of Article 8.1 do we get any reference at all in the relevant paragraphs, 56 onwards, to the fact that the key, or the first issue of concern for the appellant was that her gender identity was being undermined. That wasn't part of the court's reasoning at all in terms of the nature and gravity of the Article 8 interference. And that's a fundamental error, because it's quite clear from the case law from Goodwin onwards that it's fully recognised that your gender identity is a core and central aspect of who you are and of the rights that are protected by Article 8. And so as our first point we make in the written case is that there simply was no proper analysis by the Court of Appeal at all, recognising that fundamental aspect of the intrusion into Article 8, and therefore failing to recognise that this was not only a fundamental aspect of the private life rights, but it meant that the margin was narrowed when it came to looking at questions of justification and requiring particularly compelling justification.
But you showed us this morning the passages where Lord Justice Elias clearly adverted to your client's concerns and legitimate sensibilities.
Yes.
Are you really saying he should have repeated that in his Article 8 section?
I'm saying that that was critically important for his analysis of the nature and the gravity of the interference under Article 8.1, and the particular paragraphs that deal with this, which are 56 in particular, that there is no analysis and no taking into account of that important aspect of this case. Instead, we respectfully submit the court viewed the case exclusively through the lens of the personal information cases like MARPA. And whilst, of course, it does involve retention of sensitive, highly sensitive information, of course it does, it wasn't just limited to that. There was a separate and distinct, critically important part of the Article 8.1 issue here, which was the impact on the person's current gender identity. What we do also respectfully submit is that even if one were only concerned with this as a retention of data case, then the court was wrong not to treat, in paragraph 56, not to treat this as a serious and major interference in the same way as it had been held to be in the case of MARPA. Of course, it's a different factual context. MARPA is concerned with retention in police computers with fingerprints and DNA, cellular information. So that's obviously intimate material, but we would respectfully submit that it's no less intimate to have information and to know that the person has undergone a gender reassignment, has had a fundamental change in their physical anatomy, they've undergone medical procedures. All of that is implicit in knowledge that the person has undergone reassignment. And so, of course, we can't say it's the same situation, but we do respectfully submit that when one is looking at those touchstone questions, which were identified by the Strasbourg Court in MARPA as to whether it is part of the fundamental aspect of the person's identity, then we would respectfully submit that that the answer, there was only one answer to that. It is.
So the error is in 56, 57 in not saying and reminding oneself that this is a fundamentally sensitive aspect of core identity. Is that it?
It's first of all not recognising that and not addressing in 56 the fact that this concerned preserving the gender identity of the person. That's the core aspect of Article 8.1 from Goodwin, and that in treating it as a part only as a retention of highly personal information, in drawing a distinction between MARPA and the court's approach to the particular information that was held here. And for the reasons that I've submitted, of course it's not the same, but it is obviously material that is fundamental to the person and to the core enjoyment of the rights protected by Article 8 to personal autonomy and to control of personal information. And it includes information of a medical kind, which disclosure of is usually treated as a major interference. The other error in 56 that the court made was to rely upon the case of Catt. Lordships be familiar with that case. It was the case where Mr. Catt had been attending public demonstrations and records were kept of his attendance at those demonstrations. And it was about the retention of that information. Lord Sumption concluding, as the Court of Appeal said there, that the interference was minor because it was information already in the public domain. Whilst the court at paragraph 56 didn't treat it in the same way as minor information, it nevertheless took into account its conclusion that the information about this individual's gender reassignment was widely known, and that was treated as highly relevant when carrying out the Article 8 balancing exercise. But we would respectfully submit that one cannot treat this context as anything analogous to CAT, the circumstances in CAT. This is material that is deeply private to the individual. The fact that inevitably certain members of one's close family, for example, may know that you've had that change is not the same as saying that that's public information. Indeed, to the contrary, the evidence that was before the court was that my client had taken extensive steps to avoid being identified and to put her past behind her. And that included, even in the context of her applications for job seekers allowance, moving officers on 5 occasions once she'd experienced a situation where officers were aware of her gender identity. So this is plainly material that is private and could only be categorised as private and not in any way analogous to the situation that the court considered in CAT. And indeed, one only has to step back and understand the basis of the entire jurisprudence. The jurisprudence in this context, Goodwin and all those cases that have followed, relating to protection of the gender identity information is so that the person can move on in their lives and leave behind the historical gender identity. If that were not the case, and it wasn't essential for those who wish to ensure that they have that material to be concealed, then one can't really understand the conclusions in these cases. They are predicated upon the need to ensure that the information about the past identity does not undermine current legal and social status. And so we respectfully submit that the first fundamental error of the court was to fail to properly identify the true nature and gravity of the interference, and that therefore flawed their subsequent assessment of the justification and proportionality of the measure, which I'll move on to now. In that regard, there's common ground, as one would expect, that the starting point is the court's judgment in Bank Malat and the 4 principles that we're all familiar with, that I won't repeat and that are set out in the case. What we do emphasise in our written case is that, as my lady Baroness Hale observed in the recent Hesham Ali case, ultimately the question is whether a fair balance has been struck, and that there may have to be a different approach when it comes to cases concerning positive obligations, because undoubtedly we are in an area here, as we've seen from Goodwin and from the Hamalainen case, where positive duties are engaged. And so with that caveat, we say that the principles on this regard are clear. Where the positive duties may have most relevance is in the third principle, and the obligation and the need to look at alternatives, less intrusive measures. That's where that would have most bearing. As the court is aware, the 2 aims that were identified by the respondent as justifying, the legitimate aims as justifying this policy, were both a pensions calculation aim and a fraud detection aim. What we respectfully submit is that the court did not submit those justifications to the kind of exacting analysis that they were required to do, and that the court has indicated is necessary. For example, paragraph 20 of Lord Sumption's judgment in Bank Malat itself, and that had they done so, it is clear that those aims were either not necessary or their impact was disproportionate on the rights, and that there was here a less intrusive alternative. Because of the importance of those aims, I'm going to make my submissions as briefly as I can on those now, and dealing first with the pensions aim. So that is the need to calculate pensions. And what's important to recognise is that before Mr. Justice Simon, this was the primary aim that the respondent relied upon. And you'll see that in page 40, 89.3, MS 4568 of his judgment. What we say about the pensions aim is, first and foremost, it does not apply to 2/3 of all of those who are transgender. It's common ground that it only relates to those who are born before the 12th of December 1953, the 6th of December 1953, and it will not apply after the equalisations of pensions in March 2019. I think I might have said 2099 last time.
I thought you can't mean that.
I can't. No, I didn't. And
We'll translate.
I'm grateful from the fact that that was pointed out to me. It's fact by my client. So it's 2019. But so it is limited in numbers. It's about only a third of those who fall within this group, and will end after March 2019. It is also important to recognise, as we've seen from the Gender Recognition Act itself, that this is an area where Parliament has provided that there is retrospective effect for the pension calculation, so that you will be treated in your reassigned sex for the purposes of your pension.
For your qualifying years,
Yes.
not for your year of claim, is that right?
That's right. And what's important...
Hence, after 2019, it doesn't matter.
It doesn't matter, exactly, my lord. And what's critically important in that regard is that it's not your gender identity data that's retained on the system, your previous name, sex, etc., that's important. The critical information is the gender recognition certificate and the date that that's issued. That's what's crucial to this assessment of pensions. And of course, since May 2015, that has been masked.
Sorry,
So the information...
whoever calculates the pension
Yes.
has got to have access to the records, haven't they?
Well, they've got to have what they need to know. The information that they need to know is when was the GRC, is there a GRC, and when was it issued? Because that's the critical information.
No,
for
they
these purposes.
also need to know, for the purposes of working out whether you've got enough qualifying years, what your birth gender was, don't they?
Well, they would need to know. Well, they would need to know that, but the critical information is still the GRC, which is masked.
No, that's not...
Oh, sorry. Yes. Sorry. Yes. Sorry. What?
Whoever works out the pension
Yes.
has to know your birth gender, as I understand it.
But what they...
However,
Yes.
your point, as I may or may not understand it, is that that's a relatively limited number of people and doesn't include all the frontline staff at the
Yeah.
Job Seekers Centre.
Yes, and obviously... yes, my lord, and obviously it wouldn't include the past... You don't need to know the past name or title of the person, which is also the gender identity data that's held.
Well, you might need to know that, to know that you've truly got qualifying years. But in any event, if they've got to know your birth gender, the real question surely is how many people need to know it.
Yes.
Once somebody does, the record's got to be there, hasn't it?
And also you need to also know that there's a GRC, so that is masked, so that you've got the two systems operating no longer in parallel since May 2015, because that information, therefore, can only be accessed by specialist identified people. So in order to make the calculation, you have to access two processors. And so we do say that there is a disjunct, therefore, in the justification once you've masked certain part of the material. We submit, therefore, that given that it only applies to a limited number of people for a limited period, the visible retention on the SIS of all historical gender identity for those, whether or not it's necessary for the calculation of their pension, and obviously my client falls within that group, and it's therefore not necessary for her, does result in indiscriminate and arbitrary retention of this, visible retention of this material, because it's clearly being held for a purpose that doesn't apply to a significant number of transgender customers.
So is it your case that they ought to reorganise their systems to remove it altogether in the case of anybody born after December 1953? In other words, to make a distinction according to date of birth?
It's our primary submission that they should mask it for everybody.
Right. Yes, I've got that. You
Yes,
said that.
yes. But the alternative submission that we've made is that it should be masked for those that it's simply not relevant to. And what's also important to recognise in terms of its indiscriminate and arbitrary consequences is that, in fact, for my client's purposes and for all those 2/3 of people who it's not relevant, it has been accessed for a purpose wholly unconnected with pension calculation, because they've changed address or a contact detail or for some other information. And we do respectfully submit, therefore, that the necessity of this measure and its impact beyond those to which it's truly relevant to it means that there's a real issue about its proportionality. The pension's aim was the primary submission before Mr. Justice Simon. By the time the case came before the Court of Appeal, with the focus on visible retention of the information, because there was nothing in the pensions calculation that required it to be visible to frontline staff. They don't make the calculation of pensions, that's done by the specific body. But when it came to visible retention of the information, the aim that was relied upon by the respondent was the fraud detection aim. And it was that they said was necessary for frontline staff to have access to it, because it was more likely that fraud would be detected if frontline staff had access to that. And what we say in respect of that is that refocusing of the respondent's case was not supported by the actual witness evidence before the court. There's one witness that gives evidence on this, which is Mr. James. His evidence is 2B 627631, MS 515 to 5159.
Sorry, what's the first number, please? 515?
5156 to 5159.
5156 to 5159.
Yep. It's in 2B 627.
Yeah, 2B627.
Yes, my lord.
Yeah. That's the only one I found. It's the only one, is it?
It is the only evidence, witness evidence, that there was. And what is clear from it when one reads it is that Mr. James is giving a justification for the retention of the information.
Yes.
not for its visible retention available to all frontline staff.
Yes, but he says it's identity fraud, doesn't he, that's the problem.
He does say that it's...
Can we tackle that and see whether there's a reasonable justification, or indeed any justification, for access by frontline staff, which is what you're complaining about?
Yes, it is.
In the interests of spotting fraudulent claims?
Well, what we submit is that the properly, fairly read, what Mr. James does is justify retention per se, and not visible retention. What he does is to give two examples of individuals who had used other identities. You'll see that at paragraph 12, who were transgender. Neither of them had used it to make an additional benefit claim, but they had adopted the identity of others.
Yeah.
But what is critically important to recognise is that these cases were not identified by frontline staff. They were identified as a result, as you'll see at paragraph 16, of a general check that was undertaken on the identities of deceased children. So it was by a specialist team, his specialist team, that resulted in those being, those two individuals being identified. And as you'll see at paragraph 16, he says his emphasis is on the importance of retaining historical name data.
Well, is there any evidence at all about the value of having this data available or visible to frontline staff?
There's no evidence, my lord.
Somewhere there's something which says, well, 18, I think, is the nearest you get, isn't it? Of this statement.
But yes, but I think that's for a different purpose, which is that if the frontline staff may have the GRC or the SCR, that helps them to avoid making referrals to the fraud team.
Making referrals of what they think is fraud, but in fact isn't.
Yes, but the...
Yeah.
And of course, in that regard, it's the GRC that's also relied upon, which is now masked. So in order to fulfil this purpose, i.e. to eliminate the possibility or resolve an issue as to whether it is fraud, the frontline staff is disabled from doing so because they do not have access to the GRC that is masked.
What sort of identities are we, or are they, if you can answer this, talking about being stolen? Are they talking about the possibility that your client, who originally was male and is now female, that there might be a theft of your client's original male identity? Or if not, what are they talking about? Or can't you explain?
I think it's quite difficult to explain because in the context that we're concerned with, my client is attending the job centre in her current gender identity. She is not seeking to pretend to be... So in the actual situation that arises, it's difficult to see how this bears upon the actual circumstances.
It might. You see, the example is given in paragraph 13 of the, as it were, the archetypal case, which is borrowed from a well-known film, but has been being done by people for years and years and years and years and years. It's the more. Let's just focus on the possibility, whether it's the more likely or not, we'll come to later. But let's just focus on the possibility that what happens is that when somebody has undergone the kind of change that this claimant has, there is, as it were, an old identity,
yes,
which is no longer being used.
Yes.
Now, supposing someone tries to adopt that,
yes,
is it necessary for the and then makes a claim for some kind of benefit, whatever kind of benefit it might be, but for some kind of benefit in the your client's old identity.
Yes.
Is it necessary for somebody to be able to see that the old identity, the old identity, as it were, still has an owner, although she's not using it? In other words, that the person who is presenting themselves isn't entitled to it. And a quick way of doing that would be to look up the name and discover that that person had changed their gender, wouldn't it?
Well, it would provide that opportunity.
Yeah.
But what it wouldn't do is to actually resolve the issue because you don't have access to the GRC.
With or without the GRC, what it would show, if you're right, is a change of name from a male name to a female name.
Yes.
And your complaint, as I understand it, is that that by itself is a signal of, to some extent, of what's likely to have happened. I see why that's so. But if it's a signal of what is likely to have happened, it's also an alerter, isn't it, to the fact that somebody in trousers who presents himself saying, I am the old identity, probably isn't.
Theoretically, one can identify how that might be the case. The reality is there's nothing at all in the evidence to indicate that that is what is actually happening at all.
Yeah, I understand that.
And that in any event, it's difficult to see how somebody presenting themselves as a male with the male identity, anything about their presentation is going to need to look at the gender history. What is it about that person attending the job centre that would make you think, well, they may be making a fraudulent claim? It's got nothing to do with how they're presenting. They fit the correct gender. That's not going to be part of the signifier that this person might be perpetrating a fraud.
Well, it wouldn't. I mean, I just don't know, because as you say, we haven't got any evidence, but I'm wondering whether if you make a fresh claim for a benefit, one of the things they inevitably do is look you up.
Well, I don't think that we have any evidence about that.
That's true. It sounds quite possible, doesn't it?
Well, if it's about making a claim, then in those circumstances, aside from the fact that we don't have clear evidence as to what happens in those situations, but obviously we have accepted that the information can be retained. This is not about retaining the information, it's about visibly having it available to any person whatsoever.
So we're back to the original question. It's not so much about keeping it, it's who can look at it.
Yes, and only for the purpose that it's necessary.
Yeah.
So is it necessary for eliminating fraud?
Now, to whom is a new claim for a benefit typically made?
It would be made to the job centre.
You'd go into the job centre and ask to see someone say, I'm out of work, I need job seekers allowance, wouldn't you?
Yes, you would.
And so the question is whether that person should reasonably be given access to be able to look you up or not. Is that right?
Yeah. I think that in that example there would be a difficulty because of the SCR marker, so that individual wouldn't be able to access that information at that time.
No, but would be at least alerted to, would be alerted to the fact that there's something. Yes, I see.
Well, but they wouldn't be able to carry out to go any further with that. They would have to refer it to a specialist team, which again is why we respectfully submit that the solution of masking the information so that it's retained for the purposes that that's been identified is one thing, but having it generally available for reasons unconnected to fraud is not necessary and is disproportionate. What I would just ask the court to note, I won't take you to this because I'm looking at the time again, I've still not quite finished even this section, is if you look at correspondence between the respondent and my instructing solicitor, C815277, it was agreed in correspondence that the information could be masked and the fraud aim still met. That's a letter of the 26/05/2014, and that it wasn't actually until shortly before the Court of Appeal hearing that the Secretary of State said that the respondent indicated that it was necessary for fraud purposes, and you have that at C1245320. What we would, so therefore, the cogency of this justification has to be looked at in the context where it was not identified in the actual evidence. It was stated it could be masked, and then shortly before the hearing said that it couldn't be. What we do also emphasise is that the consequence of the changes to the universal credit system that are impending, this is at 4473 and 4474, is that the historical information will no longer be available and open to standard users, to the frontline staff. It will instead be dealt with by specialist teams. So again, demonstrating, we respectfully submit, what had been the position in 2014, that this information could be masked without compromising the aim. We respectfully submit that fatally undermines the evidence of the respondent in support of its justification, that it is not necessary in order to detect or carry out fraud. But whatever fraud is, it's theoretical, because there's no evidence at all before the court that it is being perpetrated on anything like a significant scale.
Can you give me that last reference in the hard copy version?
To the universal credit.
Well, there were two. You gave two references, and I.
Yes, it's
4473?
4473.
Yeah, in the hard copy version
749,
of CB.
Appendix Part 2C, 749.
Yes, my lord.
Thank you.
It's in the core volume at 4473, tab 11.
Answer, it's question 19, is that right? And answer 35.
What I'm referring to is a letter.
Ah,
A letter of the 20th of April.
That's right, yes, 4473.
well then I've given my colleague the wrong reference, forgive me.
Sorry. And in particular at 4474.
Internal pagination. We're in Appendix 2C, are we?
No, we're in CV now, our core volume.
11,
Or volume, forgive me.
core volume,
Yeah,
and it's a letter of the 20th of April 2017, 4473.
thank you.
And in particular, if you read the first half above, current position and next steps.
And your case is that, I mean, that's what's being applied to universal credit. Your case is that we should sort of bring all that forward, are you?
What my case is that illustrates that the justification for the visible retention of the information is undermined because the respondent has concluded that it's not necessary going forward. The consequence of that, I accept, my lord, is that the court would say that it's not acceptable to wait until this system becomes live and universal, that steps need to be taken to mask this information more promptly.
Could I just, I'm sorry to do this, but can you just go back to 5320, which is C124, which is the letter about fraud?
Yes.
At least I think I've got the right reference, and I can't quite find, sorry, I must be looking at the wrong place, but where do they say that they can cope with fraud without visible retention?
It's in, sorry.
What's this reference?
Probably 5320, C124.
That's certainly the,
It's question 19. I think my Lord Wilson had it. It's 5277 C18. It's under the heading Stephen John James.
5277 question.
Sorry, I'm lost. My Lord Wilson's going to tell me where we are.
81.
Which volume are we in?
My Lord, it's 2C,
2C.
and it's page 81,
Yes, I've got it, thank you.
5277.
And so 5320 is what you say is a retreat from that. 5320.
what is 5320? Because that's the reference you gave us.
Yes.
You didn't give us the 5277 reference earlier.
But 5277, that I understand. And
Yep.
5320, you say, is a retreat.
Yes, it is.
Okay.
But what we see from the current position is a revert back to that situation, that it's now future system is going to, the current and future system for universal credit is going to proceed upon the basis that it's not necessary for frontline staff to have access to historical gender data.
But you see, your question 19, please confirm for central criminal investigation purposes, you can manage without, you can manage with masked data.
Yes.
I think what they're saying is it's a question of spotting it in the first place, but there we are. We'll see what they say. You're having to guess rather, because they haven't spelled it out.
Well, my Lord, whichever way it goes, the burden is on the Secretary of State,
Yeah.
and this material must be subjected to an exacting analysis to show that it demonstrates a sufficient justification for what we respectfully submit on a proper analysis is a serious and major interference with fundamental rights insofar as it undermines her gender identity. And we say that it was, in this case, a situation where there was an alternative available that meets the objectives but was significantly less intrusive of rights. So in those circumstances, I now have 10 minutes to deal with my discrimination arguments, which I hope that I can at least do some justice to them. Our primary submissions on discrimination were that the Court of Appeal's approach in paragraphs 70 onwards was to conclude that there was in fact no differential treatment, that those who require, that transgender people are treated the same as others who required protection of their personal identity. And therefore there was no difference in treatment and no differential adverse impact. We respectfully submit that there clearly was, and that was because applying the well-known Thelemenos principle, transgender people are not in the same situation as others when it comes to needing to have previous gender or identity, so having previous identity data concealed. And obviously the critical difference that we rely upon is that the retention and disclosure of any identity details in this context, unlike other contexts, reveals the gender reassignment. And that was a fundamental difference between this category of person and others, whether they be victims of domestic violence, in witness protection, or members of the royal family, whoever they are that are covered by the SCR. That was a fundamental difference in her circumstances to any other that fell within this policy, and that the consequence of that is it is necessary for specific measures to be identified to ensure substantive equality for this category of person. And that analysis was simply not undertaken by the Court of Appeal at all, because essentially the argument didn't get off first base, because the court in error concluded that there was in fact no difference in treatment between the two groups. If we are correct about that, and the Thelemenos principle was engaged, and we have not treated cases unlike cases alike, then the significance of that for the justification is that the court was required not to consider the justification for the measures themselves, but the discriminatory impact. And that's obviously a standard proposition that we know from numerous cases going back to A.
But it isn't a standard proposition in relation to indirect discrimination.
No, but
In
yes.
indirect discrimination, what you have to justify is the measure.
Yes, I accept that, but in Article 14 and the Thelemanos principle, as is clear from all the case law, is that you need to justify the failure to take the specific measure.
Well, yes, of course, because I suppose that's right. I'm not sure that it's entirely correct. The trouble with Thelemanos is that it was long before indirect discrimination was recognised by the Strasbourg court.
Yes.
And they haven't thought through as carefully as our own EU-based discrimination law has the differences between direct and indirect discrimination for this purpose. So
Yes.
I think we've just got to be a little bit careful about it.
I completely agree that we do when we have three different ways in which we say there's been discrimination with different consequences. But we say in the first place, it was discriminatory not to identify the distinct and specific reason and needs of a transgender person for their identity data to be protected that was not shared by anybody else. That was unique to their particular situation, unique to their characteristic of having undergone gender reassignment.
Is that any different to the justification as it occurs in the Article 8 context, in practical terms?
In my respectful submission, it is, for the reason that there needs to be evidence justifying the difference in treatment, not just the underlying measure. And there
It
is...
comes to the same thing. They've got to be able to justify the reasons for intruding on this very important aspect of your client's life. And if they can do that under either head, they get home. If they can't, they don't.
Well, the courts have made numerous...
I mean, it's so much simpler to look at it that way. That's what,
maybe
one goes through all these different forms of discrimination, both in Europe, in here and everywhere. But at the end of the day, it comes back to a fairly straightforward issue, not a difficult issue, about justification.
Well, my lord, I would... I don't want form over substance, because ultimately, for the reasons that we've said, this not only was the interference with Article 8 rights major and disproportionate, it also did have discriminatory impacts that the court has not addressed. But one does have to recognise that in the context, for example, of number one, the Belmarsh case, whilst there was undoubtedly justification for a measure to be taken against suspected international terrorists, and the court upheld that, it did not uphold the discriminatory application of that measure to one particular group. Lord Bingham makes clear that it's the discriminatory treatment that needs to be justified.
That was direct discrimination. So
Yes.
I think we're going to find ourselves in real difficulties. You've got
Yes, I've got 2 minutes.
6 more minutes, so just tell us why you think it's not justified,
Well,
whatever it is. Work that out.
we do have an argument as to why we say that there is direct discrimination here, which wouldn't require justification under the domestic legislation, section 13.
I thought you'd abandoned your claim of direct discrimination.
But we have resurrected it in this court. But what we would ultimately say is that if you select as your criteria for a particular policy retention of identity data, you have adopted a criteria that inevitably subjects those who have undergone gender reassignment to detriment and to greater risk of detriment, because unlike any of the other categories of person, that identity data inevitably involves their previous gender and therefore identifies them as having undergone gender reassignment, which, as we said from the outset, is the core protection that they are seeking, and in fact is the protection that was intended to be provided by the SCR policy. And so in that respect, as we've set out in our submissions, this policy fails in its purpose. And that's a simple, straightforward reason why it's disproportionate, because it doesn't achieve the purpose that it sets itself. And we made reference to the AB and the Lord Advocate case, that clearly if it doesn't meet its own objectives, that's powerful evidence that it's disproportionate. But ultimately, our submission is that even if it is not directly discriminatory in that way, it clearly had discriminatory impacts and subjected my client to particular disadvantage. Again, disadvantage based upon her gender identity and that being disclosed to frontline staff. It also means that as a proportion of those who are subject to the SCR policies, the very significant number of those who are also subject to inconvenience and delay in their access to this treatment, to this particular benefit, having to wait at the office for an hour, could be delays of up to 3 days in actual payment. Although the court was correct to say that that applies to others who have an SCR marker, it's clear that this is going to disproportionately impact upon those who have this particular protected characteristic, for the simple reason that they make up the very overwhelmingly large number of those who are subject to it. And so it's a classic example of indirect discrimination. So for all those reasons, we submit that the Court of Appeal's analysis at 70 to 72 is wholly inadequate when it comes to the discriminatory aspects, that it wasn't correct to say that this could simply be subsumed under the Article 8 justification rubric because something different had to be justified. And the Secretary of State, and the respondent had not proceeded upon the basis that there was a difference in treatment when clearly there was, and differential impacts. And so that had never been properly addressed in the justifications for the policy. However, ultimately, we submit that when one properly strikes the balance between the serious and major interference with fundamental rights that is engaged here, that balance has been wrongly struck, and the less alternative measure that would have also have prevented some of the significant and the major significant differential adverse impacts on my client would have been remedied, and that was masking the information as the respondent has done for the GRC itself. The only other point that I do have to address, and if I could do that very briefly, is the question of cost, because ultimately we respectfully submit that the court's approach to costs as a answer to the masking, essentially that because it would involve cost, that therefore meant that the respondent wasn't obliged to adopt the less intrusive measure. Our submission on that is twofold. One is that costs themselves cannot justify significant interference with fundamental rights, nor can they justify any discriminatory treatment that's identified. The Court of Appeal's reliance on the case of MacDonald, which is the case involving resort to incontinence pads rather than having nighttime attendance, is not authority for any proposition that costs will trump fundamental rights. If one looks carefully at that case, there wasn't a finding that there was an Article 8 interference nor any positive duties on that local authority to make the provision that was sought. So it's whatever was said about costs in that context is obiter, and in any event wouldn't support any proposition that costs would always determine the outcome for rejection of less intrusive alternatives. Certainly, we would respectfully submit that the position that the respondent has adopted on costs has not been consistent. When one looks at the evidence that was before the court in respect of the cost of the GRC masking, the initial evidence before Mr. Justice Simon was that it would be in the region of over £360,000 to make that individual change. But the evidence is that, in fact, it was £10,000 when it was actually made. It's obviously, as you'll see from the Statement of Facts and Issues, no scoping exercise has been done because of the £25,000 costs. But perhaps if it had have been, it would have been identified very much sooner, that part of the change would have been very much less of a burden. But ultimately, we do respectfully submit that the costs that have been identified at their most significant is £1 million to make the changes. And when one can...
Perhaps we'll wait and see what they say on the other side.
But our...
You had 2 points to make.
the 2 points are that it couldn't justify the interference.
And the second was, in any event, it doesn't.
And that on the facts, it hasn't. If you subject that part of the justification to any exacting scrutiny, one sees that these are really by way of speculative assessments, as was shown by events when the GRC was masked.
Thank you very much indeed.
There's my submission.
I think we've asked you all the things that we wanted to ask you. Thank you very much indeed. Ms. Brewer? Right. Mr. Bourne.
My lady, my lords, although this appeal pursues many legal lines of attack, in reality there are two main issues to deal with. The first one is the respondent justified in retaining historical gender identity data, or at least as it's put today, in retaining it in the way in which it retains it? And second, does the SCR policy discriminate against the appellant or infringe her human rights? Before I come on to submissions ground by ground, I just wanted to make 3 introductory observations about those main issues. First, on the first question about data retention, the appellant no longer focuses, as she once did, on the holding or retaining of her data per se. Now, here in the Supreme Court, the focus is on the fact that they're held in visible form. The mandatory order, which it said that the appellant seeks, which was set out in my learned friend's note of last week, the 6th of July, is an order not to delete the information but to mask it. And it no longer is being argued that it's unlawful to retain it full stop. However, there's been really very little discussion of what exactly is meant by masking. And if masking means that nobody can see the data, well then of course masking is equivalent to not retaining. Masking can only mean that the data will still be visible to some people in some circumstances. And it would seem that a solution of that kind would be considered by the appellant to be acceptable and lawful. And that's very important, because the current state of affairs is, indeed, that the appellant's historic gender data are only visible to a limited class of people in limited circumstances. And when one comes to assess the policy about which of the state's officials should be able to see that sort of data and when, the court may feel that that's very much the sort of operational decision in which considerable weight should be given to the opinion of the decision maker, and the courts should be cautious about, in effect, telling the respondent what policy to adopt. That is, of course, a theme I will develop later in the submissions. My second introductory observation is that the appellant attacks the SCR policy only in combination with the retention policy. I won't take you to it now, but we see that very clearly in the conclusion to my learned friend's written case. There's no freestanding challenge to the SCR, and indeed, it's hard to see how there could be, because the appellant can opt out of the SCR. The third and last introductory observation is that although our written cases contain some detailed debate about the different types of discrimination and the fine distinctions between the legal tests for each type, well, that part of the debate was dealt with very briefly just now, and there's a good reason for that. which in my submission is that this appeal is most likely to turn on whether the court considers that the respondent is justified in doing what it does. And it's in the context of that specific question that we will encounter the secondary, more practical issue of whether, in protecting data via the SCR policy, the respondent infringes the appellant's legal rights in any way. My lady, my lords, our case in summary is that retention is justified by two legitimate aims whose existence has been found as a fact, and that although it is and has for a long time been conceded that the SCR system may cause some inconvenience, that system doesn't cause any breach of the law. With
When you
that
say inconvenience, do you mean interference with Article 8?
we say short of interference with Article 8, my lord.
So Article 8 is engaged, but it's not interfered with. I mean, if there's no interference with Article 8, you don't need to justify it.
My lord, that's right. We've always conceded that retaining someone's sensitive personal data engages Article 8, and there is a debate about whether we interfere with it. What we've said in our written case is that retaining the data is and will always be an interference which requires to be justified. In this case, we will say we have little difficulty in justifying it when you look at the way in which...
That's all right. I just wanted to make sure that you did accept that there was an interference.
Yes,
which
we
had to be
accept
justified.
interference on that side. What we have not accepted is that the SCR policy interferes.
Oh, no.
So the inconvenience like
It's the
delays-
retention, you say, is the interference.
That's right.
But the SCR is not.
Precisely. With that introduction, the order of these submissions will be as follows. First, I will briefly address the question of whether the court should entertain the appellant's points that were not taken in the Court of Appeal. Second, I will...
Well, don't spend much time on that because we'll decide for ourselves whether we're going to.
My lady, I'm grateful for that hint. Second, I will emphasise some important facts, and in particular, I will need to go back to the question of whether the respondent's policies have the effect of revealing the appellant's transgender status to anyone. And in particular, I need to go back to what the courts below actually said about it. Third, I will take what in the statements of facts and issues is issue number 1, namely whether the Gender Recognition Act has the effect for which the appellant contends. Pausing there, my ambition is to cover that ground this afternoon, so we'll know I'm getting into hot water if I'm much short of that at 4 o'clock. Then fourth, I will go to the nature and extent of interference with the appellant's Article 8 rights, and it's at that point that I plan to respond to the material that we've had from the intervener. Fifth, I propose to address the various types of alleged discrimination. And then sixth, why the policies and practices are justified. And I will say, of course, justified in relation both to Article 8 and, if necessary, to Article 14 and in relation to indirect discrimination. First, then...
Can I just say, don't forget it, someone will tell us about birth certificates, will they, at some point?
My lord, I hope that tomorrow we will contribute to the sum of knowledge on birth certificates.
Needn't be very long, it's just been nice to know what you actually get.
We'll do our best.
Well, it should be a combined effort.
I'd be very sorry if we couldn't agree it. The new points, then. Just for the record, the appellant relies on 4 points that were either conceded or at any rate not taken in the Court of Appeal. The Article 3 and any relevance thereof, direct discrimination, harassment as a subspecies of direct discrimination, and the contention that the respondent's policies are not rationally connected to legitimate aims. There is no dispute between us on what the legal test is. The Appellant's Counsel's note of last week referred to relevant factors, and they reflect the case law on this topic. For the court's note, we, in our case, have placed particular reliance on the Privy Council case, New Zealand Meat Board and Paramount Export, authorities number 70. One thing I will just add is a reference to the judgment. It's a dissenting judgment, but not on this issue, of Lord Walker and Lord Nichols, paragraphs 63 and 64, which the court will find at MS 2505. That's a helpful distillation of what is a stringent test. May I perhaps, notwithstanding Lady Hale's warning, may I take a minute just to go to that now?
Despite what is said in the cases, people raise new points all the time. And sometimes they get away with it, and sometimes they don't. That was why I was suggesting that we will make up our own minds what we're going to do with these new points. But by all means, take us to these.
That's very clearly understood. What I feel I should place on the record is the height of the hurdle that you've got to get over before you're one of the people who get away with it. And it's
Brian, you're going to show us, are you, why you've suffered some identifiable
Yeah.
disadvantages?
My lord, I will touch on that in a second. At 63, we read a reference to the case of Ahamouth from 1931. It must be only under very exceptional circumstances that an issue dropped in the Intermediate Court of Appeal and for that reason not dealt with or referred to by that court can be revived before this board. And that principle had a certain longevity because it turns up again in the case of Grobbelaar in 2002, which is then cited, the oft-cited phrase, only rarely and with extreme caution will what was then the House of Lords permit counsel to withdraw from a concession in the Court of Appeal.
Withdrawing from a concession is somewhat different. And of course, in the Privy Council, there's an added reason for reticence in accepting new points, because if they have not been argued before the local Court of Appeal, the board is deprived of the opportunity of understanding how local courts might have dealt with it.
My lord, I accept that that must be a relevant factor in some of the cases. What we see from the domestic cases is that the same broad principles are applied across the board. And just the final point about the principles I wanted to pick out of paragraph 64 is just at the very end of that paragraph, namely that it would be wrong to run any risk of doing injustice to the other party. The party wanting to take a new point or resolve from a concession has to persuade the court beyond doubt that it has before it all the relevant facts. And my lord, I accept Lord Kerr's point that may have special resonance in the Privy Council, but it's not to say it doesn't apply in other types of case as well. The other case to which I will not take the court now, but to which I'll just give you the reference, is the decision of Crane in the Court of Appeal. The MS number is 414. And in Lady Justice Arden's judgment from paragraph 18, the court will find what may be a helpful summary of what I think are all the relevant authorities on the point.
Well, it's not really about authorities. I mean, your best point is that if experienced counsel hasn't thought these points were worth pursuing in the Court of Appeal, it may suggest those are not her most important points. I mean, but even if we think they are important, then it'd be wrong on a case of general importance like this to exclude them.
My lord, I of course don't disagree with that, but what I would point out is that every case that comes to the Supreme Court, pretty much by definition, must be of general public importance. And yet there isn't, and I submit shouldn't be, a principle that the door is any wider in this court than it would be, say, in the Court of Appeal.
But there are distinctions in this sort of context between public and private law cases. If you've got a case between two private parties, whether they are individuals or businesses or whatever, there may be good reasons why reasons that the court doesn't know about, why particular arguments weren't run, why particular things were dropped or particular concessions made. Litigation behaviour in those circumstances is different from public law litigation behaviour. Well, yes, people may drop an argument, as my Lord has just said, because they don't think there's much in it. But as my Lord has said, if we think it's a pretty important argument and it's a matter of public law, so therefore affecting the public generally, we may feel that we're on a bound to look at it. Of course, the other thing that we'd be interested in is whether anybody's been put to any disadvantage.
Yes.
But that's a very different sort of question.
My lady, it is, and to that short list of relevant principles, I would add only one more, that whilst it may sometimes be important to allow new or defunct arguments to be resurrected at appeal stage, I submit there is a countervailing argument, nevertheless, of enabling parties, which include public bodies, to have finality in litigation and to know where they are. And that's why, in my submission, one must do more than pay lip service to the rules of pleadings, notices of appeal, and indeed what's said in the Supreme Court's practice direction about what to do if you want to take a new point. And whilst, yes, it can be in the public interest to entertain a point of that kind, there are times when it may also be contrary to the public interest to relax the rules and to perhaps convey among practitioners a sense that in the Supreme Court the gateway may be wider than it really is.
I'm sure practitioners aren't going to have that impression at all, but just to the list of various factors, perhaps might be added the consideration that the court, as a public authority, deciding whether there's been a breach of a convention right, has a responsibility to ensure that any justification put forward for proportionality, and in consequence, any attack upon the proportionality of a measure must be examined. There's a lot of debate as to whether the Supreme Court should conduct its own analysis unencumbered by the views of the lower court, but park that for the moment. We do have a particular responsibility when it comes to dealing with the question of proportionality, not to neglect an argument if it is pertinent, simply because it has not been raised or has not been canvassed as strongly as it might have been in the lower courts.
And I would accept that if a point appeared to have merit of that kind and it could be shown that there wasn't prejudice to the other party, that will be the sort of case in which the court will take a more liberal attitude to it. But even then, in my submission, it is accepted within human rights law that one is allowed rules of court and courts are allowed to stick to their rules. And therefore, in my submission, it is always a balance. And I'm just going to take a couple of minutes now just to make some comments on the 4 points in question, obviously with a view to persuading the court that they fall on the other side of the line. To take them one by one, Article 3, first of all. When we read my learned friend's written case, it seemed that Article 3 might be rather more important than perhaps it's turning out to be. All I say now is there seems little point in the appellant relying on it because it's highly improbable that the reference to Article 3 would change the outcome. What my learned friends say, in effect, is that the risk of serious harm to transgender people is a relevant factor in the Article 8 balance. We don't dispute that a factor of that kind, if it is a real factor, will be a relevant one. What we say is the problem with that submission is that there's no finding below, and also no evidence, that any person has suffered treatment passing the high Article 3 threshold by reason of the operation of either of the respondents' relevant policies. And that is no doubt why this claim is actually brought under Article 8, not Article 3. So our point on that is that it goes nowhere. The second one is direct discrimination. What my learned friends argue is that the two policies in combination reveal the appellant's identity, whereas they don't have that undesirable effect for other people. However, it is clear, I submit, that the policies are not only applied to transgender customers. The retention policy applies to everyone, but is said to have a special impact on transgender customers. SCR is applied to several categories of customer, and again is said to have a special impact on transgender customers. Whether or not those are good claims, we submit that they are quintessentially claims of indirect discrimination. And of course, it is now a legal truism that conduct cannot be both indirect and direct discrimination. And once again, we say that once one just takes a good look at that strand of claim, it is apparent that it is going nowhere and adds nothing, and it's not the sort of important, potentially meritorious argument to which one might take the more liberal public interest attitude. Thirdly, the alternative packaging for direct discrimination is said to be harassment. And that's a new point taken for the first time in this final appeal. And it's on this one, to answer my Lord's question of a few minutes ago, that I do say there is some prejudice. It is perfectly true that the claimant has, from early in her claim, alleged some misbehaviour or unpleasant behaviour by staff at job centres. There are some brief references to those things in her witness statements, to which the respondent replied with a statement saying it had no record of a complaint being made. The court will find what I hope may be a helpful summary in Annex B to the witness statement of Ms. Terry Mann. I won't go to it now, but I'll give you the page reference, at least the electronic one, MS 5948. A number of isolated allegations then were said to support the appellant's case overall, but were not said to give her an independent cause of action. In the circumstances, I submit it's not surprising or reprehensible that the respondent, over and above indicating that it had not had a complaint, didn't challenge them further. Had it been suggested that there was an independent cause of action of harassment, it might well have been thought necessary to challenge the allegations. This may or may not have become one of those rare judicial reviews where you might even need oral evidence. But in my submission, there is a genuine risk of unfairness in allowing a case based on incidents of harassment to be run for the first time here in the Supreme Court. And then the fourth and last point, which I'll take very briefly indeed for now, is the appellant's U-turn in relation to the respondent's legitimate aim. Can I just take you for a moment to the Court of Appeal's judgment, paragraph 55, which is MS 4543. It's the first sentence. There is no challenge to the judge's conclusion that the pension and fraud detection objectives are legitimate aims, and it is not suggested that the policies are not rationally connected to those aims. My lady, my lords, in the light of that, it seemed a little unfair when my learned friends said that there had been a lack of exacting analysis, as they put it, of this issue. There was a lack of exacting analysis because it had been conceded. That's all I want to say on that one now. We propose to perhaps do a note overnight, just pulling together what has been said in Part 18, Further Information and Correspondence, about universal credit, because I know that my learned friends say that it's new information about universal credit that perhaps gives them a springboard to run a new argument. And I propose to deal with that rather more precisely tomorrow. Can I then move on to my section 2 to talk about the facts? The SFI, of course, sets out the facts in full, And again, just for the court's note, we have tried to give a helpful summary of the key facts at paragraph 14 of our written case. For your note, it's MS 4279. In particular, I submit that it's important to avoid any exaggeration of what is actually done with the appellant's personal data. The appellant's gender data are not on the JSAPS system, which is used at the job centre. That system will hold a customer's gender data only where a benefit claim was made in the previous identity and the same claim remains live in the new one. Generally, the historic data that this case is concerned with are held on the CIS system, and frontline employees access that system only in exceptional circumstances where a legitimate reason for accessing CIS is established. All access to that system is monitored and policed, and the appellant herself has pointed to evidence of employees being dismissed by various public bodies for having unauthorised access to that system. I would like, if I may, just to colour in one more detail of what actually happens when that system is accessed. And I wonder, please, if I could take the court to MS 5756. I'm hoping someone might help me with a manual reference to that page.
5756.
5756 electronic, appendix 2K, page 176.
It might be 1228.
It is, my lady, yes.
Okay, this is a screen.
Thank you.
At least it looks like a screen to me.
Your ladyship is absolutely right. It is a screen. This is the account summary screen that a user sees when, having a good business reason to do so, they access somebody's record on the SIS system. We were given this as a real-life account summary screen of a person whose identity and personal details have, of course, been anonymised. Now, sorry, I'm just struggling with my own screen at this moment. Yeah, in the lower half of this screen, you will, about halfway down, you will see in the middle of the page a field saying sex. Everyone's sex field has next to it, to the right, the two letters M and H, which are hyperlinks. And M, I think, stands for maintenance, and H stands for history. It's if you click on H for history, you will go to another screen, and that is the preceding page, 5755.
57.
At least I say a different screen. It's the same screen, but there's a pop-up.
Well, there's a pop-up on ours.
On
Yes.
Pop-up on.
The pop-up says former 6 start date.
If you click on H.
So if you click on H, you get the pop-up.
You get the pop-up.
And that's how you see historic gender data. Now, the short point I want to make about that is that it simply is not the case that when an official goes to SIS to do something else, for example, to change an address, that they are confronted by things like gender identity, former gender identity data. In terms of the precise information that we are talking about, you don't see it unless you go looking for it. And it seemed to me important to make that clear, Because whilst I don't for a moment suggest that it's difficult to find, and if some mischievous employee wanted to snoop into data, well, we don't say that it's difficult to do so over and above the fact that their use of SIS is audited and tracked. But it is simply not the case that accessing SIS equals being told about sensitive data of the kind that we're dealing with.
Can you show us where any change of name appears? Because what's said against you is that that effectively reveals the same information. At the moment I can't see that, but it must be somewhere. Is it H by requested name? No.
Name one.
Yes, I think that's right. I'm grateful to my colleagues. Top of 5756, indeed, top of either of these two pages,
Yeah.
there is a hyperlink saying name history.
Name history.
That, yes.
Second from the left.
In short, the important point is the front screen does not say Jane Smith, formerly known as John Brown. It says Jane Smith.
And name history will show up title change as well, will it? Presumably it will. Yeah. Someone
I've been
behind,
told the answer is
someone
yes.
behind you says yes.
They know better than I do, my lord. Now, in the light of these facts, including the way the system works, in my submission, it's hard to imagine that this challenge would have got this far if the case was purely about the retention policy. A point which I will go on to emphasise when we come on to justification and so forth is that we are here dealing with data that are sensitive, but it is a small amount of true information held under strict precautions, accessed only for a legitimate business need by professional officials. In my submission, the real thrust of this claim is about the SCR policy. And when one comes to judge the SCR policy, its advantages and disadvantages, one of the things we will ask the court to keep in mind, though I say right now it is not an answer to the claim, the SCR policy is designed to ensure that sensitive information about protected customers is given fuller protection than would otherwise be the case. My lady, my lords, that is a verbatim quote from paragraph 17 of the SFI. It is an agreed fact that that's what the policy is designed for.
Paragraph 17.
17 of the SFI.
Yeah.
For more about the SCR policy, may I, in fact, just go to the SFI at paragraph 20, MS 4184. It actually, yes, sorry, bottom of 4184. Where we read that there is a team of personnel who have permanent access to SCRs for use with legitimate business need. Frontline staff at the job centre do not have permanent access. Temporary access may be obtained only where a legitimate business need is demonstrated and access is authorised. Access not needed for routine issue of benefits.
So can I just understand, Mr. Bourne, SCRs are within the CIS? You referred to permanent access to SCRs on the CIS.
The SCR protects people's data on all relevant systems. Whenever an official tries to access them, either on JSAPs or on the CIS, the protection will spring into place.
I see, but so SCRs aren't part of the CIS, they're an add-on.
Yes.
They're separate.
Yes.
And we've been looking at these CIS printouts. They're nothing to do with SCRs. That's coming now. Is that right?
That's right. What your lordship has seen on the screenshots is the data held on the CIS. SCR is what stops somebody looking at them unless they're authorised.
Thank you.
So if you typed in a name to the CIS, something would pop up to say, this is a person who's a special customer records, and so you've got to go through other hoops to make progress.
Precisely. And that's what in turn leads, unfortunately, to delays and so forth.
Did I write down correctly, Mr. Bourne, with reference to paragraph 20 of the SFI? First, there's a team with permanent access. They're special people.
Yes.
Frontline staff are different. Frontline staff access is not needed for ordinary claims processing. Is that what you said, or have I got it wrong?
What they don't need to process ordinary benefits is access to CIS. So when a customer goes into the job centre for a routine visit for job seekers allowance, no one will access the CIS. Instead, they will access the JSAP system, which is the routine one.
If I go in for my fortnightly renewal, as it were.
Yes. If they raise some...
First claim. Or don't we know?
Offhand, I certainly
Certainly not in evidence anywhere.
I beg your pardon?
Certainly not in evidence anywhere.
I think, my lord, the best I can say about that is I will make inquiries.
All right.
I'm just going to leave you with the other paragraph numbers from the SFI, as, like my learned friend, I'm finding that time and tide waiteth for no man. 23, 24, 25, 30 and 31 tell you what we say are the key facts about how SCR works. And within the same passage, 27 and 28 tell you about the attendant inconvenience. Now, may I come on to the question of whether these systems have the effect of, as it's been called, outing a customer?
I'm so sorry, Mr. Bourne. You've given us the politest hint that you don't want too many interruptions because you're losing time. I'm interrupting you. I apologise. But paragraph 27 of the SFI, first sentence, the operation of the SCR policy creates inconvenience and delay in accessing benefits.
Yes.
I thought you said that almost always the frontline staff won't need to access SCR.
My lord, no.
Why does it create inconvenience and delay?
For this reason. I'm sorry, I haven't made it very clear. Two computer systems in particular are relevant. The one that is generally used for frontline staff to process benefits is called JSAPS. The great big system that's got everything on it is the CIS. Frontline staff generally won't need to access CIS. However, when a customer has an SCR marker, it restricts everyone's access to all of their data.
And that includes the everyday payment of job seekers allowance.
It does indeed.
Yeah.
And, my lord, may I say, any clarificatory interruptions of that kind are entirely welcome.
Thank you, Mr. Bourne. Thank you very much.
Anything that challenges you is distinctly unwelcome.
Be careful what I wish for, perhaps.
Things you know the answer to are always okay.
What we have seen in evidence from the appellant and from one, I think, of the intervener's witnesses is that there have been incidents at job centres which suggested that officials knew of a person's transgender status and behaved inappropriately in one or more ways. Lady, my lords, can I put it on record, all parties agree that any such behaviour is wholly deplorable. What we do not know about any such incident is how anyone's transgender status may have become known to any official. In particular, we do not know, and there is no evidence, that any incident has been caused by any person seeing any information on a computer screen or by any customer being identified as having an SCR marker. We understand why the appellant speculates that that may be the case. The way she puts it in her first witness statement was, she said, "I fear that," those are words I quote, that an incident may have occurred because information had become known in a particular way. But we submit that there isn't any sufficient basis for any such inference to be drawn. Whilst it's true that an official in any such case may have seen an electronic record, they may also have seen documents, such as letters or claim documents relating to an old name. They may have been told by colleagues who dealt with a customer in a previous identity, or of course they might just have guessed for themselves about somebody's gender status. But what is, I would suggest, even more important than that is that any such incident isn't a part of the relevant policies, it's a breach of them. In our case, we've given the references to evidence of the respondent's suite of different policies prescribing the standards expected of staff. And the court's also, of course, heard about provisions of the criminal law, notably Section 22 of the Gender Recognition Act. If employees misbehave, then that may be the basis for a serious complaint, but in my submission it does not by itself get the the appellant's judicial review anywhere. And in my submission, the evidence doesn't get the appellant further than that. The various statements establish that the SCR policy causes inconvenience and delays in the ways that we have already conceded, and those apply to everyone who is subject to the SCR policy. Can I then come back to the question of what exactly the courts below said about the revealing of anyone's status? Can I start, please, with MS 4531 in the judgment of Lord Justice Elias? Paragraph 5, which is on 4533. What we read here, 5 lines down, in addition, any change recorded in the sex field would identify that the reason was gender reassignment where that was the explanation. However, all references to the GRC have been masked. There is therefore nothing now visible to frontline users which states in terms that the person has had a gender reassignment. And then this, even so, in most cases, that will be the obvious inference to draw from the information which is still recorded. And pausing there, that's never been in dispute. If one sees in a record, if one actually looks at the data and sees that John Smith used to be called Jane Brown, we do not disagree that gender reassignment may well be inferred as the reason why that's happened. Can I then please turn forward to paragraph 17? The Court of Appeal here records that although the Secretary of State considers there are good reasons to maintain gender information on the SIS, it's appreciated this has to be handled with sensitivity and respect for Article 8 rights. The SCR policy is designed to achieve this and to ensure that intrusion into private life is kept to a minimum. The Court of Appeal had in mind that design. And may I then go to 19, which was the paragraph upon which I asked my learned friend to alight earlier today. The fact that a transgender person has an SCR marking does not of itself demonstrate that he or she is a transgender person. There are other categories of persons whose names have changed who also have this system, and there are some examples
Apropos
there.
that, could we go back to the SFI?
Lady, yes.
I'm sorry, I'm interrupting you too, which is paragraph 16, which lists the people who might have an SCR marking.
Yes.
I feel, is that an accurate list?
To the best of my knowledge, it is.
Well, it looks a bit odd to me. It has, for example, victims of domestic violence. That's a lot of people. That's a lot of people. Far more than have gender recognition certificates. Seems to me likely that this is a very specific subset of victims of domestic violence.
I'm sure your ladyship is right about that. I can't define for you the subset now, though, of course, I can take instructions on it.
Well, it would help, bearing in mind that some weight is being put upon the proportion of people who have an SCR marking, who are in fact transgender people. So it would help to have some explanation of this, because it's very weird. Individuals subject to witness protection orders, yeah, that's not probably very many, but there will be some. The next category cannot be right. Those who may be vulnerable to arranged marriages cannot mean arranged marriages, nor is the word vulnerable particularly apposite in relation to arranged marriages. It may, of course, refer to forced marriages, although the footnote suggests it refers to something completely different. But there we go. You see what I'm getting at? There are some small categories of people, but there are two categories there that would be enormous if they were taken literally. So I'd like some more information about that.
My lady, absolutely, and overnight I will try and answer that question. My understanding is that perhaps the important word in the first sentence of paragraph 16 is include. If one looked at an exhaustive list of everyone who has an SCR marking, they would correspond to people who are as described in our sub-paragraphs, but it's certainly not intended to mean
not
that.
enough. Yeah.
And the other point that I think I can emphasise now is that in some of these categories, in particular the ones your ladyship has asked me about, these are individuals who ask for an SCR marking and who are given it, e.g. because they correspond to one of the descriptions that we've given here. That's my understanding of how it works in those categories.
Well, if you could either point to where this is all explained in the enormous amount of data that we have in front of us, or provide further explanation, which you'll share with the other side, that would be helpful.
My lady, of course.
But don't do it now, you've got other things to do.
Yes. We were just looking at the Court of Appeal's judgment, and I took your ladyship to paragraph 19. Can I then alight on paragraph 22? This is in a description of what information is available to officials, and what I wanted to emphasise here is that where an official sees a gender history, including titles, names and sex, in the third line of 22, this does not of itself show that the customer is transgender. Far more often, the sex has to be changed in the record because it was incorrectly entered in the first place. But usually the change in title and name will demonstrate that the customer has changed sex. Ms. Harrison earlier today then took you to the passage at 25 to 27, and whilst she submitted that these are findings by the court, my submission is when you read the judgment as a whole, these paragraphs can only be simply recording what the appellant's complaints were. And indeed, were it otherwise, if those paragraphs were said to mean that the policies out transgender people, it would seem immediately to be straightforwardly inconsistent with paragraph 19 that we just looked at, just on the preceding page. Can I then go to the heading above paragraph 53 as we come to the court's actual findings? The heading tells us that it is here that we are dealing with the question of proportionality, and therefore, if I can put it this way, the court's verdict. And then paragraphs 56 to 59, as that heading shows us, are dealing with the proportionality of the retention policy. And therefore, that would be a strange place to find a finding about the effect of the SCR policy. May I then go to 63? Lord Justice Elias here giving concluding remarks on this limb of the case. Referring to just about halfway down the paragraph where his lordship says, whilst recognising the genuine distress felt by this appellant, I do not think it is seriously arguable that the limited disclosure of gender history to those who need to know is a sufficiently significant intrusion. And again, in my submission, that description of what's going on cannot sit with a finding that the policies have an outing effect. And then on the same page at 65, his lordship said, the fact that the policy was intended to benefit the appellant is not an answer to the Article 8 challenge. And then the second half of the paragraph, it is not the terms of the policy itself which gives rise to a breach, it's the fact that it does not go far enough. It was said, again, the policy may, at least in theory, not merely fail to achieve its objective, but might actually make matters worse. That would be so, for example, if the policy sought to restrict the number of people likely to have access to the information, but in fact increased it. But one would hope that it would be very exceptional for a policy to be so incompetently drafted or applied. Again, a very odd thing for the court to be saying if in the same breath it was finding that actually that is what the policy was doing. And then at 67, his lordship comes on to the specific complaint. The second Article 8 complaint about SCR is that it creates delay in processing, leads to delay in payment, and that in practice it draws the attention of officials to transgender customers, which is precisely what the policy is designed to avoid. So we now come to the matter in hand. After, in 68, ruling that any administrative failings aren't a breach of Article 8, at 69 we get to what is the high watermark for the appellant. As to the complaint that the SCR policy is in practice drawing attention to transgender people, in some cases that may be true, although the presence of the historical information means their status will in most cases be obvious in any event to those who have access to it. And his lordship goes on to say it is the price for the system of protection. But what I particularly wanted to emphasize that in that high watermark passage, what we read that the policy may do is draw attention to customers not draw attention to transgender status. And we quite accept, of course, that the appellant will not want attention drawn to her, and we will come on to deal with that in the debate about justification. But it is an important inaccuracy to say that the courts below have said that the SCR policy reveals that you are a transgender person. And my lady, my lords, if we're right about this, and if the true position is that whilst unwelcome attention is drawn to customers, but that any revelation of their status merely occurs inevitably when somebody actually looks at the data and sees what the data says, but that's not the effect of the SCR policies, then that disposes of what Ms. Harrison at the outset today said was the key issue in the case. I have wholly failed in my ambition to cover the first of the grounds of appeal as well as this issue, so I will just, before I stop, I will say a couple more things about outing very briefly. First of all, in the reply that was served by my learned friends last week, they placed reliance on some of the contents of the SFI. There's only one comment I think it might be helpful or important for me to make on that, and that is that footnote 38 in the SFI is potentially misleading.
Footnote
Footnote number 38.
38.
Because there you appear, by agreeing the footnote, to have accepted that paragraph 27 was a finding.
Yes.
In comparison with your submission half an hour ago, that it was a recital of the appellant's arguments.
My lord, absolutely. Those are the words I'm referring to. In the end, if we've described it incorrectly, that's my mistake, and I apologise for it. What, of course, the SFI can't do is change the meaning of the Court of Appeal's judgment. And in the end, simply we ask the Supreme Court to decide what it was that the Court of Appeal found. And in my submission, when one puts it all together, the meaning is tolerably clear, and by my error, footnote 38 simply overstates what happened. I've already commented on what the appellant's evidence about outing consisted of. I will just give the court a reference to one part of the respondent's evidence about outing in case it proves helpful. At MS 5137, the court will find the second witness statement of Ms. Terry Mann. And at paragraphs 22 to 24, there's some information about how transgender customers are a minute proportion of the DWP's customers. Most officials may never have dealt with a transgender customer, and a point I've already made, there are many potential ways in which an official could find out about someone's transgender status over and above learning it or inferring it from anything on the computer. And finally, just a point on the law. My learned friends cited the cases of Goodwin and the case of I for the proposition that special measures are objectionable where they may reveal a gender change or call attention to the transgender status of the person. Well, what we say about that is simply that it will be a question of fact in every case as to what actual effect a type of measure has on a claimant, whether that infringes, prima facie infringes, Article 8, and if so, whether it's justified. In my submission, there's no overriding rule of law that special measures will be unlawful if they call unwelcome attention to somebody who has a transgender status. And of course, in Goodwin and I, one's got to remember the context, which was the overwhelming breach of human rights inherent in the lack of legal recognition of gender change, and where the state tried to rely on special measures as a defence to that. It's perhaps unsurprising, with hindsight, that the European Court, in fact, took a dim view of the effect of those measures in that kind of case. Lady, my lords, I'm assuming that would be a
Well
convenient
timed.
moment.
1 minute.
That clock's slightly fast. I tend to go by the clock on the computer, which shows that you're a minute out. So, well timed. We shall look forward to resuming the hearing tomorrow morning at 10:30. Court is now adjourned.